So call the case.
Good morning, Your Honors. The matter before the court is the case entitled Cindy Gaines versus Edmund Gaines III, case number 24 AP 396. Representing the appellant, Edmund Gaines III, is Harold Stevens. Representing the appellee, Cindy Gaines, is Eugene Rakow.
Thanks very much. Good morning, counsel. We'll hear from counsel for the appellant. Please introduce yourself, identify your client, and then proceed.
Good morning, Justices. Justice Reiber. Yes, that's Harold Stevens representing Edmund Gaines, the defendant in this contempt proceeding that he's appealing from. Quite simply, the Mr. Edmund Gaines maintains that that when he entered into the settlement agreement with his wife or his ex-wife, that he was not aware that his mother's trust, which provided him with income, would prevent him, the trustee, from giving him money to pay for the alimony and property settlement monies that he was supposed to pay under the settlement order. And his mother's trust makes it very clear that the trustee could not use the funds to pay his ex-wife. And in fact, the settlement agreement was entered into in 2022, and Mr. Gaines, his mother's attorney, Attorney Pratt, on May 20th, 24, wrote a letter to Mr. Gaines, which is part of our appellant brief, page 14, which basically said that when she created the revocable trust, he was one of the trustees, and she remained the right to remove him for any or no reason, and he basically got removed on the basis of this settlement order to protect the assets and from the wife's claim. So basically, the evidence showed that he has actually a negative income of $1,700 if he doesn't get funds from the trust. Thank you, Justice. I reserve 2 minutes.
Okay, thanks very much. We'll hear from counsel for the appellee. Please introduce yourself, identify your client, and then proceed.
Eugene Rakow. I'm representing Cindy Walker Gaines, who lives in East Hampton, Connecticut, and is living on Social Security of $1,600 a month. This case involves a very, very substantial estate that Mr. Gaines, along with his mother, who were the owners of the property, both of the real estate and a brokerage account, they then, 2 months before the divorce, filed deeds to the property, putting it into a trust. It was clearly designed so that Mr. Gaines wouldn't be paying monies to my client from the trust fund. But the trust fund was basically to defeat the opportunity for my client to be paid by Mr. Gaines, even though he knew that the trust was in effect. He was a participant in it. He signed the deed, so he clearly knew what his financial circumstances were. Now, I know they've warned us about rattling papers here. I want to give you an idea of where Mr. Gaines is. If you look at, I know you won't look at it now, but the exhibit provided by Mr. Stevens shows that Mr. Gaines' living expenses are $17,359.65 per month. Their exhibit, admitted on the day of the hearing, provided the day before the hearing, against an income of $6,557. There's a shortfall of almost $11,000 per month that is paid through the trust. That's acknowledged by Mr. Gaines. Where he lives is in a mansion in Shrewsbury, a 5-bedroom, 2-kitchen, 2 living room, drawing room, a library mansion on 265 acres, known as Saddleback Farm because it basically owns the Saddleback Mountain. Mr. Gaines stopped paying anything in June of 2023. He's behind in spousal maintenance now, $45,000 and rising. He has not paid a property settlement of $12,500, which he was supposed to pay in 2023. He has not refinanced the Connecticut home and awarded and executed a quitclaim deed to my client, which is also part of the order. It is specious for him to argue that he does not have the funds to pay this. He knows he does. The court has ordered him to do it. He's been in front of 3 family judges. There's a whole series of orders that the court can see in the printed case. And on top of that, in the printed case on page 18, Mr. Gaines acknowledges that he has bank accounts totaling over $32,000 as of the date of the submission. He clearly has the money to pay it, and he isn't paying it, which is one of the reasons the court ordered attorney's fees awarded to me because of his obdurate behavior. To me, this is one of the most significant misuse or manipulation, I think is the best word I can come up with the court system. He's just filed motion after motion, knowing that my client doesn't have the ability to pay the legal fees that are involved here, but he does. And by the way, exhibit that I just referred to, the Exhibit C, puts court-ordered spousal maintenance as one of his expenses, listed at $1,800, when in fact it's $1,400. So it's listed as something that's being paid, but it's not being paid. If I have some time, I'd reserve it.
Well, I don't think you have that prerogative. If you have anything else, please go ahead.
I think I covered the trust. The other assets that were put into trust was a brokerage account with about $800,000 in it. Mr. Gaines was listed as a co-owner of that. By the way, his mother passed away a few months after the divorce. So the property and the right of being trustee is now all in Mr. Gaines. There's also Florida land that he owns with his brother worth about $500,000. There's a whole series, and you'll see it in his affidavit, of personal property that's located on the farm property, vehicles, farm animals, various other things. So his total assets conservatively are over $2 million. And to say that he can't afford to pay the little amount that he agreed to pay to my client,
Okay.
Specious.
Okay. Now your time is up. Thank you very much. How much time does the appellant have, please?
Appellant has 3 minutes, 28 seconds remaining.
Counsel?
Yeah, thank you, Justice Reiber. So basically, this all comes down to one legal issue, as far as I can see, and that's the question of whether or not Edmund's mother could set up a trust with these provisions that would prevent the trustee from providing him with funds to pay for alimony or property settlement for his wife. I've researched the law on this issue, and apparently I don't believe that Vermont has made in fact, a black letter decision on this issue. But from my reading of most of the law across the nation, it appears that many courts respect this type of restriction. Some courts do not go with it because of maybe a public policy issue that husbands need to support wives, ex-wives, and involved in property settlement. But the fact of the matter is that this trust was put in place before he got divorced, and his ex-wife knew about these trust provisions, as well as Attorney Rockow, and chose to enter into the settlement agreement with Mr. Gaines. And unfortunately, he just simply does not have the funds, the income to afford it. He certainly lives a very good lifestyle. There's no question about it. But all those assets are in trust that Mr. Rockow has just described, of which the Saddle Mountain Farm is owned by the trust. Pretty much all property and accounts are held by the trust. Edmund is a retired major from the Air Force. He's on a pension. He doesn't have a lot of income of his own. The trust does pay for a number of the expenses, but most of which go to support the maintenance of the farm, which is trust property, which Edmund pays for. So unfortunately, there's just not the income there to take care of paying for these property settlement and alimony expenses. And finally, Edmund strongly believes
You have
that
1 minute, counsel. You have 1 minute.
Edmund strongly believes that the initial settlement agreement should have never been accepted by the judge at the time because he believes there was a conflict of interest that didn't get disclosed. But that's part of our seeking relief from the order. And again, he believes that the order was void ab initio, that his relief from the order should have been heard first before we got into this contempt proceeding. Thank you, Justices.
Okay. Thank you very much. Please.